Good morning, this is your Kelso Report for Wednesday, February 8th, and I'm your host, Clark Kelso. Well, the country has been waiting quite a few years while the same-sex marriage issue winds its way through California's political process, its state courts, and now through our federal courts. Yesterday, by a 2-to-1 vote, the Ninth Circuit struck down Proposition 8 in Perry v. Brown. The majority's opinion by Judge Reinhart was very narrow. It did not reach the question of whether equal protection guarantees a right to same-gender marriage. Instead, the majority simply held that Proposition 8 did not satisfy the unconstitutional animus standard from Romer v. Evans. Romer was the case where a Colorado initiative took away from gays in Colorado existing rights barring discrimination. And the United States Supreme Court held that the only possible justification for that initiative, animus against gays, was not a constitutionally legitimate state interest. The dissent in Perry yesterday notes that Romer was actually a very different case, where the initiative actually took rights away. By contrast, Proposition 8 did not affect any legal rights at all. It simply withheld from same-gender couples the designation of marriage, a mostly symbolic action that communicates the state's view that opposite-gender couples are preferable. Well, next we have to wait to see whether the Ninth Circuit bothers with an en banc here, or whether they let the case pass on. It almost surely will be taken up by the Supreme Court, and Kennedy, I think, will have to decide on the court whether Judge Reinhart's reading of his opinion in Romer is correct, or whether the dissent has it right. We'll stay tuned for more action in this case. Next we have a habeas corpus case from the Ninth Circuit. The defendant was sentenced to death based on 2 aggravating circumstances found by the sentencing court in Nevada. Those 2 factors were held improper on appeal, and the case was sent back for resentencing. He was again sentenced to death, this time based on several aggravating factors that had previously been charged by the prosecution, but about which the first sentencing court had been silent. Well, the issue before the Ninth Circuit yesterday in Farmer v. McDaniel was whether that silence meant the defendant was impliedly acquitted of those elements of a capital murder case, in which case another attempt to procure a death sentence would be barred by double jeopardy. The Ninth Circuit held that the sentencing panel's silence did not impliedly acquit the defendant of those aggravating circumstances, so the double jeopardy clause did not apply, and the state could again attempt to impose the death penalty. Next we have an environmental law case under NEPA. The Department of Energy has been trying to site a biosafety level 3 facility at the Lawrence Livermore National Laboratory for some time. Now, in an earlier round of litigation, the Ninth Circuit upheld all aspects of the department's original environmental assessment, except it had failed to consider the impact of a possible terrorist attack. So, DOE revised its final revised environmental assessment to consider the environmental impact of an intentional terrorist attack on the proposed facility. And the Ninth Circuit this time affirmed the district court's decision to grant summary judgment to the department, thereby dismissing the plaintiff's NEPA challenge. According to the Ninth Circuit, the DOE took the requisite hard look at the possibility of a terrorist attack, and a hard look is all that is required by NEPA. Next, a trademark law decision from the Ninth Circuit. Under the Lanham Act, you may recall, a design that is non-functional can qualify for trade dress protection. However, in order to ensure that protection of that trademark does not create an unfair competitive playing field, a design that is functional is not entitled to trade dress protection. After all, absent a patent, all competitors must have equal access to functional designs. Under the Lanham Act, there's actually a presumption of functionality, and the plaintiff bears the burden in a trade dress case of proving non-functionality. Well, yesterday in Seacolt v. Wuxi Shanxi Construction Machinery, the Ninth Circuit affirmed the district court's conclusion that the design of a traction hoist was functional. More precisely, that the plaintiff did not prove non-functionality, and therefore it did not qualify for trade dress protection. Now we turn to the California Court of Appeals, first a criminal law case. The defendants in People v. Latham were convicted of the second-degree murder of their 17-year-old diabetic daughter, based on the jury's conclusion that the parents had conscious disregard for their daughter's life when they failed to obtain medical treatment for her in the days just before her death. The defendants argued on appeal there was insufficient evidence of conscious disregard, but the jury actually had plenty of evidence that the parents knew the risks associated with diabetes and knew that it was a life-threatening disease if not properly treated, since they had previously rushed their daughter to the emergency room in what is commonly known as diabetic shock. During that prior visit, they were provided with educational materials that would have fully informed them about the risks associated with diabetes. In addition, in the week preceding her death, various neighbors and visitors told the parents, "You need to secure medical care for your daughter," because her physical condition was so obviously deteriorating. But they failed to take any action. For the 4th District, this evidence cumulatively was enough for the jury to make the necessary findings that the parents were aware that their failure to obtain medical treatment endangered her life, and that they failed to obtain such treatment in conscious disregard of that risk. A tragic case. Next, we have a case under the Public Records Act. Now, the public's right of access to public records in California is, as you know, constitutionally grounded. And unless a record fits within a statutory exception, it must be produced. In Long Beach Police Officers Association versus City of Long Beach, the 2nd District held that the names of police officers who have been involved in officer-involved shootings in Long Beach were not protected by any of the statutory exemptions contained in the Public Records Act, and the names therefore were required to be disclosed to the Los Angeles Times. As the court explained, there's a legitimate public interest in the conduct of individual officers, and there was no countervailing public interest in the non-disclosure of the names of those officers involved in shootings. That's it for today's Kelso Report. Have a great day in the law.